Well, today we're going to start with something ripped straight from the headlines. We talked about it before we made the migration to video. This is a probably a little known case for most Americans, but it's now drifted up into the Supreme Court, and this has been on the horizon for a while. But the Supreme Court finally is making some movements on a doctrine known as the Chevron Deference, and this has big impacts for business and governance. So, Gerry, what's going on? What is the Chevron Deference?
So this goes back to a 1983 case. Chevron is the Natural Resources Defense Council, which, if you recall, at the time it was Reagan era. At the time, this particular group, Natural Resources Defense Council, was trying to push for more, I guess you'd say, stringent, regulation of what was considered to be polluters at the time. Chevron, I guess, being one of them, and without getting into the great details of jurisprudence on this particular case, what it did was it gave the court sided with the National Resource Defense Council in this case, and it gave more, shall we say, power to the administrative state. So it wasn't just, in this case, the EPA would have been the what would we say, have the jurisdiction over environmental matters as it relates to Chevron. But this case was used then over the ensuing, now where are we, 40 years. 40 years. Get my math right. It's been used over and over again to argue for why the administrative state has the ability to make rules, if you will, because the case, I think the simplest way to explain it, allowed for what in fact, I think the terminology was even reasonable, quote unquote, leeway, for whatever better word, there's probably a better word, for the bureaucratic state or for administrative agencies to have reasonable jurisdiction over making rules. Well, therein lies the problem. They've taken that term reasonable and they've run it into 40 years later, where I would argue Congress in many cases are absolutely abdicating the responsibility of making rules and laws even, and they've turned it over so much to the administrative state that the administrative state has run amok. Well, there's now a case before the Supreme Court that is trying to undo that and say, no, wait a minute, laws and rules and what have you are needed to be put in place by legislatures, by Congress. So this is a classic case of you open the door a little bit in probably what at the time was considered to be a reasonable decision, that over the course of 40 years is part of the reason why we have such an incredible amount of bureaucratic creep. It's not bureaucratic creep anymore. It's bureaucratic tsunami. The bureaucratic state has grown so large, and this is, we've talked about this over and over again, and it's why we get so, animated about the growth of government and the size of government. We're witnessing with what's happened with bureaucracies and the administrative state, putting regulations that are just so onerous, especially affecting small business, that we look to a case like this, and I'm trying to recall the name of the case. It doesn't matter. It's called the Chevron Deference case now. Well, that by the way was the
Isn't it Natural Resources Defense Council versus Chevron?
That was the Chevron Deference case. So now what the case is, I can't remember.
This current case. Sorry.
Who versus who on this particular one? That's before the Supreme Court, and from arguments in the case, it sounds like the Supreme Court is leaning towards overturning this Chevron Deference case, and which will have significant implications for. It's the fishing industry. The fishing industry, I believe, is the one that's at issue with this particular case that's outstanding. But anyway, it's almost irrelevant. What's more important is the actual, what it sets as precedence, or what it undoes, with respect to, just how much regulation. And we've talked about, when you go back to, the 8,000 to 4,000 problem, the, number of public companies that we've shrunk to in the last 20 some odd years, we believe that's very significantly tied to, regulations like Sarbanes-Oxley, even the NASDAQ settlement that took place over the spreads in NASDAQ securities, and how much market makers make on making markets in small NASDAQ traded securities, to Dodd-Frank, to, the alphabet soup, I would say, of various, regulatory regimes that have come into place. Almost always in the wake of, excuse me, in the wake of some crisis. It's an attempt to always, solve problems that or avoid. We'll never have this happen again, and it ends up opening up Pandora's box, and the next thing you know, you've got the law of unintended consequences 40 years later, and we've let the administrative state run amok. So, as believers in free enterprise and promoters of small business, and being a small business ourselves, we're very much looking forward to possibly getting this overruled. Now, of course, the other side is, oh my gosh, now you're going to have massive pollution, and the rivers are going to be dirty, and the ocean's going to be a mess, and the air horrible.
Pardon me.
Who wants to breathe bad air? Okay.
Where's the mute button?
What's that?
Where's the mute button? I just sneezed. Sorry.
Excuse me. Excuse you. Anyway, so that's one to keep an eye on.
So I would add a few things to this. Number one, Justice Jackson recused herself from the case because she was involved. She was on a 3-judge panel on the DC Circuit that heard arguments on a related case. But she has raised concerns that indeed the Chevron deference would give the courts too much power and lead judges to engage in policymaking. Wow, it sounds like a very unusual criticism coming from her side of the political aisle.
Exactly.
And also I would say that, look, I was 8 in 1983. I know that probably every claim that the Reagan administration made in the name of the EPA might not have made sense and been wise stewardship of our resources. I'm not going to stand behind every decision they made. But I would also say that even more current iterations of the EPA have not demonstrated a lot of competence. We've got a case where this impacted a family member of mine very directly. But in 2015, in Colorado, the EPA released a bunch of toxic waste into the Animas River, and with the Gold King mine disaster. That was just a complete fiasco. And then you have the case of John Beale, who was the EPA agent who claimed to be a CIA spy and defrauded the government out of about $900,000. So, I mean, the EPA, and obviously these are anecdotal, but the EPA is part and parcel a classic example of a government agency that just has given too much power. And this is the administrative state that Trump was largely elected the first time to try to dismantle, and was largely unsuccessful in doing so.
Well, and I think it's, I noticed it interestingly, Paul Clement is the lawyer that's arguing for the fishing industry, the herring fishermen. I think his quotes are worthwhile. He's basically saying that, the current system means that Congress never has to weigh in and reach a compromise on the toughest policy questions, because one side or the other can just wait for a change in the executive branch every 4 or 8 years, and the rules will swing back and forth based on the views of the political party in power. That gets to my point of Congress has abdicated responsibility for making laws. They have to do that's what Congress is supposed to do. They're supposed to debate. They're supposed to, put forth, potential laws, possible laws, debate them, come to a conclusion, vote on them, and then that's it. And, he's hitting the nail on the head here, and I think, frankly, this should go beyond politics. Either side should be frustrated with this because we have a system in place where these issues get solved and laws are made based on compromise and give and take and the debate that goes on in Congress. Unfortunately, Congress has given up debating. I think I really do. I think let's put forth this idea in the form of a law and let's debate on it on both sides, and let's just see where we come to a conclusion in our vote. The politics will still obviously come into it. Whoever controls may well win that particular argument depending on which side they come down on. But that's what the system is supposed to do. It's not supposed to be a bunch of unelected bureaucrats making rules that are like Mr. Clement is claiming is flowing back and forth every 4 to 8 years based on who's running that bureaucratic state. So I think regardless of which side of the political spectrum you come on, you shouldn't like that. That shouldn't be elections determine what the people want, and then the people's representatives go battle out what they're going to make laws, and then that's it. And then the administrative state should be nothing more than just carrying out what the laws are that the Congress passes. I mean, is there anybody that really thinks that's controversial?
Yes,
I know there are, and that's part of the problem we have today for sure. That's why things can be construed as being a real mess, but that's what our country is. That's what it was built on. That's what's made it great. We better start paying attention to these kinds of things. And this case is potentially a huge, step in the right direction. I think, as Clement says, I can't think of a better way to mark the 40th anniversary of the Chevron decision than with an overruling. In our view, this has really gotten out of control, and that's the point. It's not that one side or the other will say, "Oh." And in this case, it's the left that's against this. And I'm not sure what that says about the left, because I do think this should be politically agnostic. They obviously have gotten quite good at using the administrative state to their benefit. Well, okay, so sorry, but that's not the way our system is supposed to work. You got to go out and prove to the people what you want, get elected, and then you can put laws in place that you win the vote on in Congress, and the rest of us just have to live with it.
Well, and even if you think that too much power is resting in the judges' hands, and you think that judges aren't accountable enough, because some appointments obviously are for significant periods of time, if not for life, in the case of the Supreme Court in particular, there's more accountability there than there is in nameless bureaucrats. As we saw during recent hot button cases, if people don't like what the Supreme Court's saying, they'll show up at their houses, breaking federal law, mind you, to do so. But they will. Those judges do have to answer it to a way that any bureaucrat who's making law on the fly won't have to do. And there's always gray areas. There's a place for judges to interpret laws. There's a place for Congress to make the laws. But nowhere in the intent of our system were nameless bureaucrats supposed to be the ones making policy.
Yeah, it's very simple. Congress makes laws. The agencies, as organized by the executive, the president, carry out the laws, if you will. And the judge and the judicial branch interprets laws when there's a dispute.